Добрый день, уважаемые.
Ladies and gentlemen, hello and welcome. It's 12:15 right now, so we must start our work. I am Alexey Guznov, I'm the director of the legal department of Bank of Russia. And today we would like to discuss with our speakers all the questions related to regulating FinTech and the fact if and how the FinTech is a challenge for the law and how law should react to financial technologies. This issue has been discussed very actively in different platforms. For instance, at the St. Petersburg International Economic Forum, I believe we had 5 panels dedicated to this topic, or related to this topic, to FinTech and law. There were really prominent panelists which held provocative talks in the sense that it was a good provocation. And it resulted in passing several bills in the State Duma regulating digital assets, and this was a good catalyzer for this process. Now, some time has passed, and we are understanding some of the topics in detail, but some of them stay unexplored. And I would like to discuss those questions, those areas today. I would like to introduce the speakers. Nikolai Zhuravlyov, member of the Federation Council and the first deputy of the Committee for Financial Markets. Nikolai Zhuravlyov is also a member of National Financial Council, and he is one of the most prominent authors of the laws on regulating a financial market. He has co-authored the law on the financial assets, on the law on crowdfunding. So his opinion is really valuable for us. Yana Pureskina, Director of the Financial Policy Department in the Ministry of Finance, and it's her department which defines the state policy of the financial markets, of the new financial technologies, and the way how the Ministry of Finance considers those questions is crucial for understanding the concept and tactics. Oliver Völkel is a representative of Stadler Völkel attorneys at law. I've heard Oliver talk at the Legal Forum in 2018. He was one of the speakers at one of the panels, and he presented in detail the experience of European countries. In Austria, for instance, there are different approaches, and our approaches differ in the Russian law and the doctrine of law which represented Oliver, approaches to digital assets. But this is how we should discuss, this is how we should share our opinions and concepts so that we understand the full palette of the different options. Yelena Sidorenko, she's professor of the MGIMO, Institute for International Relations, and she also heads the Institute of Digital Economy and MGIMO. Yelena has been working on the promotion of digital technologies. Students of MGIMO take part in different conferences, and she is also an expert for the State Duma, for different committees, and I hope that her opinion will be insightful for us as well. To the left, we have Anatoly Aksakov, a prominent person. I think he don't need an introduction. He is the one who decides about the fate of the bills passed in the State Duma. He heads the committee which actually works on those bills, and and I hope that he will introduce us to this topic as well. Anatoly Kozlechkov, Vice President of the Association of Russian Banks. He is responsible for the legal side of legal activities of this association. He represents the association in different expert councils and in the Committee on the Financial Markets and the State Duma. It turned out that 3 people have to do with the Association of Russian Banks here in a panel, but it's all right because we value the opinion of the banking community as well. Andrei Yemelin chairs the National Financial Market Council. Andrei publishes a lot of articles, and the National Council is also very active in promoting new technologies, biometric identification technologies, and it provides expert advice. So his opinion is valuable for us as well. And last but not least, Artyom Tolkachev. He is a lawyer and he specializes in blockchain technologies. He is the CEO of a Sputnik DLT blockchain integrator, and as far as I know, he is he's very active in cryptocurrency and blockchain projects. To start the discussion, I would like our speakers to provide their opinion on the questions that are raised at the beginning of the session. What are the main challenges for the law in terms of innovative financial technologies? And if you feel there are challenges, what are the solutions for them? How law can contribute to balancing the financial technologies? I would like to remind you that our schedule is quite tight, so I will be limiting your time, but you will also have the possibility to support them with your applause. Nikolai Zhuravlyov, the floor is yours and your reply to my questions. Thank you very much. Thank you very much, Alexei. Thank you very much for inviting me to this panel, which I hope will be of interest. The most interesting part will be the last one, when Mr. Aksakov will be talking about our law on financial assets. I would like to begin with commenting on the yesterday's first panel discussion, where we were talking in detail about competition in the financial market. The opinions were different. Mr. Greff thinks that there is competition in the market. However, the rest of the attendants did not agree. And I think that there is not sufficient competition in the financial market, and the problem is not about the share of the state sector in the banking industry. 50, 60, 70% happens already in happens even in developed countries. But the share of a single player in the financial market is really awful. The 30, 80, or 90% in different products belong to one player, to one market player only. Many products of Sberbank are universally known, and the role of the state should be to balance the situation regulatively, and maybe we should think about us introducing a state control of a share of specific market players so that are not too large. The Central Bank of Russia has done a lot in the past several years to promote digitization and to enable statewide projects like the payment card MIR or the system of transmitting financial transactions. Recently, we introduced a new law on transactions with foreign companies, and I hope that many of the bills we just mentioned will be developing and will contribute to the development of our financial system. We now have introduced a sandbox. We have representatives of Central Bank of Russia here, and every week we receive several applications from the market players to take part in this regulatory sandbox. And thank you very much to the Central Bank for this project, for making it happen. Now, the credit history, loan history, the scores. We now introduced a bill to have a nationwide credit score for natural persons, so that everyone can monitor his or her financial standing. We will be developing this system further. In autumn, we will amend this law in the State Duma, and I believe that we should also be developing a universal insurance score for the citizens, because there's a serious problem with the car insurance, with the compulsory car insurance. Next, combating abuse. We recently made the penalties for breaching the laws of financial transactions more strict. We have also introduced the possibility of suspending financial transactions for suspicious customers for a period of 2 to 5 days. And here we also to work on, and I'm the proponent of giving the central bank the authority to block websites with incorrect information about financial institutions, about their shareholders, about their management, and about the employees and the management of the Central Bank of Russia. As part of those novelties, we could also combat phishing sites advertising Ponzi schemes. The situation with Kashbury financial pyramid only proves that we need those initiatives. Remote identification is what we've done recently. We need to develop it further. Unfortunately, it does not perform as well as we planned, because not every large market player are enthusiastic about providing data to the system. 20% of the network should be up according to the law by now, and by the next year, 100%. Starting February 15, we also need to be launching the marketplace, which wouldn't be able to work without a identification platform up and running. And as soon as we launch it, we need to dig on, and we need to include small and medium-sized enterprises into this project. We need to simplify access through financial institution using outsourcing systems, because this is a key chain element in the whole development of the Russian economy. And I see that I don't have much time. The last thing I would like to say, we support the system of rapid payments, a project of the Central Bank of Russia. I believe this to be another key project which will enable which will improve the situation with the competitiveness of the Russian markets. The rapid payments are now concentrated within a single market player to 80%, and we are able to support this project.
Thank you, Nikolai. I would like to ask one question. You have referred about the remote identification, and there was an applicable law. It was enacted real fast, but I think the challenge that you have mentioned indicated that the banking community was not ready for the introduction of such a technology, and some other steps could have been taken in order for the law to become functioning within the required time schedule. The banking community is ready. It is just that one big league player is not willing to act by the law, and the CBR role as the key shareholder and the regulator is to use coercive action to force all the actors, including big actors, to apply it and to enforce the law. And the next question is to Elena. You see what the challenges are, what the issues are, and I think the scientific communities discuss the issue. What do you think is the most acute issue in the relationship between the law and the financial instrument? We have covered this issue at the level of the scientific expert community, and we are communicating with the business community, and we are overjoyed that the big business is getting interested in the digitalization issues. We understand that the law is not capable to give answers to many questions, and when we deliberate what these questions are, I would like to say what those are. One are the security, cybersecurity, the digital security. We will not provide the security of the digital services consumers, and we should act in this area. Another thing is the development of new financial assets, digital financial assets. And I think the draft law, which is in the State Duma now, it will be reviewed, of course, but in compliance with the demand that the big business has and the actors, the consumers that will be using it. Another component is the definition of digital services. Many companies, when they launch digital services, they realize that due to the lacking law, they cannot either launch the process or are not capable to validate it. Law is needed. And like smarter contract implementation does not allow the signatories to protect their rights, to prove when this particular contract comes into existence, and when the parties will change their ownership or anything. Another important component is related to investments. We realize that the business is on the search, on the lookout for easy money. Do we have digital capacity for that? I think yes. Could the law support it? No. And those issues should be addressed. Another important component which is not discussed, but we are pondering over it. It is the external relations activity and the issue of sanctions imposed against Russia. We won't be able to forget about it, and large corporations, in my perspective, will have to think how digitalization will help them to optimize the whole thing and to improve the situation of those big companies at the international market. Talking about our own experience, let me share my certain ideas, and you might be aware of these not through the discussion of the expert community, but also through the activity of some actors. So we have a vision of the new revision of the draft law on digital financial assets. This law should be supported by a number of the tenants. It is cryptos, currency, and it should have a special arrangement and regime that should be regulated by the bylaws and guidelines, recommendation of the Central Bank of the Russian Federation, starting from the definition of the cryptos and how the procedural issues will be resolved to organize the trading in cryptocurrency. Next question. What will be the requirements of the license for the platforms? And there should be a framework law defining that special cryptocurrency has got special regime, special arrangements. And we should differentiate between the digital format of the securities and derivatives. Everything that at the moment is defined clear-cut as covered by the law on securities. And we should be frank and sincere to say that we are talking about the digital format of the physical brick and mortar papers. And the other thing is the digital asset is the manifestation of the legal contract. So when we are looking into the future, how the business will be developing, we should make our mind whether we will be having crowd mining, and we will have to bear it that some entities will issue as part of the civil code contracts certain units, certain entities that should be in support of the business processes that exist in this country. And there shouldn't be tough and strict regulations that exists when applied to the digital securities, and that kind of arrangements should not apply to the digital cryptocurrencies. So it should be supported by three things. It is the law, responsibility, and liability. And we should understand that we cannot name all the things as digital financial assets, to have an umbrella blanket definition. We should differentiate between different formals, and we will have a discussion platform to talk about those things. But if a decision is taken that there will be cryptocurrency in Russia, we will have to realize that this will be a financial instrument, a financial asset, and it will be up to the central bank to give a definition and what are the minimum standards of supervision and regulation and oversight. And in my perspective, and we are ready to provide the arrangements to the State Duma. We should have three assets with its own regime and arrangements, and the regime will relate to the organizers of the tradings of all the three types of the assets. The liability will have to be defined, and there are certain arrangements with respect to the authority of the regulators, like a central bank or the other regulators. But it is clear that in this context, we should understand that that kind of law should not infringe the interests of the state and the rights of the holders of the securities, because the criminal code is still applicable, and there are special articles that relate to the breach of the emission procedure, and if you are in breach of law, you should be held liable. So, as a model, This story should develop, but we will have to understand that we will have to face the major economic tasks. I have a sort of a legal question, not to raise the issue whether the cryptocurrency is needed. What is it for you? Is it a currency, a commodity, a derivative financial instrument? And I have a definition that cryptocurrency is an artistic value. What's the legal status of the cryptocurrency for you? Thanks for your question, Alexei. Indeed, I am a specialist really in cybersecurity, and when I analyze all the documents related to the cases, legal cases in Russia, I can see that we do not file a suit where cryptocurrency could be deemed to be the object of a crime. And the legal specialists believe that cryptocurrency is not part of the civil relationship as part of Article 128 of the Civil Code. We need a definition of the cryptocurrency, at least in the framework law. Until then, we won't be able to answer that. For me, it's not a property, and we won't be able to protect the interests of the people who have fallen victim of the hype related to the cryptocurrencies. That's what my perception of it as a legal specialist. But as a natural person, I can say that it's just a hype, and I think sooner or later it's a fab now, and it will be gone eventually. Thanks for your comment, and I would like to receive the comments of Oliver Volker. You see what the discussion is in the European Union and in Russia, and there are certain opinions worded out at the level of European Commission, Parliament, and looks like the regulations will get tougher, more stringent, and the regulators are evaluating the cryptocurrency differently now, and the international regulators see there are more risks associated with it. What's your position regarding it?
So, thanks for inviting me to this conference. The original question was, how can the law contribute to a flourishing of the financial markets and to cryptocurrencies? Perhaps one sentence to my background. So I'm an attorney in Austria, and our law firm is concerned to about 60% or 70% with cryptocurrency-related law and initial coin offerings and blockchain technology. So this is my main focus. I will spare out other aspects of innovative financial systems, let's call them that way. And so I think the utmost important aspect for a legislator or a regulator also is not to be too much in the way of companies. Every regulation you pass, every requirement you stipulate is a hindrance to innovation and makes it a bit more difficult for companies to flourish. I think that's the most fundamental approach. And also what the legislator can do is to really curtail the regulator a little bit. I mean, I have seen this in many European countries. Germany is the most prominent example for that. In Germany, the regulator has qualified cryptocurrencies as a unit of calculation, makes it a financial instrument, and de facto there is no market in Germany developing on this technology. And people are coming to Austria and to neighboring countries. So, and also, by the way, perhaps of interest for you, a court has recently deemed this classification of cryptocurrencies in Germany as financial instruments as being unconstitutional because the regulator has taken over something that usually would be only allowed to the legislator. So the legislator could also curtail the regulator a little as far as possible. And then if the local law does not already provide for all of this, I think it only needs to establish some sort of fundamental structure for the economy to work. I mean, we all have this buzzword of token economy in our heads, and if you take a second and think about what is necessary to make such an economy work, we can think of the most important things I would like to address here. So how do you transfer ownership over assets? You mentioned that in your remarks. How about dealing with cryptos in the context of the criminal code? What about crypto theft? How can we protect ownership, so to speak, of people on their crypto assets? What about jurisdiction? What laws should apply? How do you determine where cryptos are actually located? Are they always located where the people who have access to their cryptos are located? So, for example, the bitcoins that I have, it's only a very little amount. Are they now in Russia, or do they remain in Austria? How about enforcement? What if you get a verdict by court that you need to enforce? How do you make sure that you can enforce something on the blockchain that is, by definition, at least at the moment, not changeable or alterable by other people? And I have a prediction because of that, which I would like to point out in the end. How about insolvency rules? What do you do when companies who are an exchange, for example, becomes insolvent? How do you make sure the courts do also get access to the funds of this company? And at the same, so I think what the law can contribute and what it should limit itself to is provide for these basic rules of the game. If you have these rules established, I think everything else will work out just fine. But at the same time, you should also make sure that people are not abusing the system. We have seen Ponzi schemes and initial coin offerings which were just fraud. People receiving money from others without any controlling. This can also not be the case. And I would like to make two predictions here, which I have reiterated a couple of times at different talks now, and my time estimation always varies. But at the moment, I think, first of all, and perhaps this is already the case in Russia, I don't know it, but it's certainly not the case in Germany, Austria, Switzerland, and neighboring countries. My first prediction is in about 3 years, regular banks will start offering bank accounts denominated in cryptos. That's a key presumption. And another prediction that I only recently got to realize is the following. I think that in about 10 years' time from now, we will see that the legislator treats different sorts of blockchains differently. And why do I think that? As I said before, imagine that cryptocurrencies become part of our daily life, that you will one day pay with Bitcoin at the local store. At that point, at the latest, sometimes we will have to enforce court verdicts. And we can't really do that on a blockchain like Bitcoin because you need the private key and you can't really force people to give you the private key or perhaps they destroy it. And I think we as a society will face a situation where we see that transactions have taken place on the blockchain, which we really would like to change, but which we cannot do simply because of the technological limitations. And I mean, blockchain was designed with that in mind, so don't get me wrong, it's a technical feature and it's an astonishing development. But I think we as a society cannot really deal with this technical limitation. So in my estimation, we will see a differentiation on the legislative level, treating cryptocurrencies that enable the state to make changes, based on a court order or verdict or for enforcement action, who enable these sorts of changes and to promote these sorts of cryptocurrencies and to somehow limit the application or perhaps even altogether not allow the use of blockchains who are not technically savvy enough to accommodate these needs. I think at a broader societal level this could very likely happen, and I think this is where things are moving in the next 10 years. So that was an important point for me to make. Have I answered your question also?
Yes, thank you very much. You answered your question, but you've created another question as well. And this has to do, well, you raised a very important issue. That's true, because blockchain created a challenge to the basic principles of including the European Declaration of the Human Rights, the enforceability of a court decision. And if we have a court decision, like a decision concerning cryptocurrencies, if they are arrested, how they are actually implemented in practice. I do understand that it's technologically impossible, but if a European court has taken this decision, do you have those legal cases where they are tried to be enforced or enforced at the end of the day?
At the moment, we do not have any, civil court cases where you try to enforce the returning of cryptocurrencies, for example. What has happened is that the Austrian prosecutor wanted to seize cryptocurrencies, and they were unsure how to do that on the legal basis. Usually what they would do is simply, if there was some criminal activity connected to the cryptocurrencies, simply go to the place, collect the computers, and hope that whoever was in possession of the cryptocurrency didn't have a copy of their private key. And this has turned out to be not very functioning, or not functioning very well, because usually people had some sort of way to restore, and then simply, I mean, what I want to say, it really doesn't depend on whether you collect the computers. You only need the private keys, and if they remain with the suspects, then they can simply transfer the cryptos to another place. This is what has happened in the past. So the Austrian prosecutor now are trying to move cryptos to safe destinations. But this only works if you get hold of the private key. So I think it really, we will as a society need some sort, and perhaps one last remark. Do you remember the hard fork of the Ethereum blockchain, the DAO disaster? That's an example why we can't really use the technology if we don't have the means to change it. And because you said it's technically impossible, that's not really true. You can always agree on a technical protocol where there are some super users that are able to make changes. So I think this, for us as a society, that's really a need. Yeah.
Thank you very much. Thank you very much for your comment. This is highly interesting, and I would like to move on to Andrei Yemelin. You further discussion, and despite all the richness of this topic of the regulation of financial technologies, it turned out to be related to the regulating digital assets. But what are other challenges related to FinTech, in your opinion? Thank you very much. I would like to step away from the details indeed, and I would like to rely on the experience we collected over the years of Finopolis, starting the meeting in 2014 when Ms. Nabiulina launched the system. We made a long way. We did a long way. We did a rapid payment system. We did a biometric identification system. And we need to make something to have a brighter future in this regard. And I love the words spoken yesterday that the white paper is currently much more worth than the actual code of the solution. And we had a question at the previous panel: what should we do for the technical innovations to be implemented in a more suitable and a more efficient and a more comfortable way for the market players, and so that they are implemented in no time or in minimal time? We've spoken a lot about this in different platforms. I see an acute need for a systematic evaluation of technological evaluations, technological implementations of the normative acts of the laws and bylaws. This was included on the resolution of the State Duma, and thank you very much to Mr. Aksakov for that. And the whole experience of the pilot projects shows that without taking technological details into account, we will at the end meet the same problems. However, I'm optimistic. I believe that it all functions well, but my concerns. First, no one ever takes into account a real service which needs to be used, starting from the state information system where we needed to, we needed to integrate with another information system as well. The banks did not knew anything about that, and we implemented this law 2 years behind schedule. This took a lot of time, and we now, another example, suddenly have a requirement to check our passports, to check the customers' passports in one of the laws. But the database to check the passports is barely digitized. It works very, very badly, and we query the responsible authorities for that. And now, 3 years behind the schedule, 3 years after the law has been passed, we now we will now have an API to check the passports. But currently, it's being done manually. But you all know at the same time the recommendation of the Central Bank of Russia that if a passport check fails, we're required to decline the identification. There is a rule on that concerning the bank reserves as well, which causes financial loss to the banks. It's the 4th year that the service has been running. It is running suboptimally, but we are forced to do that. The laws for 482, where we are required to check the mobile number, where a failed check on the telephone number is a risk factor. The law on a system to actually check those phone numbers has been introduced as a draft law only this spring. So several months after the implementation of the law 482. So there should be an infrastructure as well to collect the data to ensure compliance with the existing laws. This is required for the improved identification, for the improved rapid payment system. We need an infrastructure system in place. We need a universal centralized access for this, not requiring every one of us to communicate with every single mobile operator, for instance. And you all know the fees on the SMS messages and on the communication, which are currently under scrutiny of the Federal Anti-Monopoly Service. Because currently the prices for SMS messages are considered monopolies high. We think that a pre-evaluation of a technological implementation, of the feasibility of the implementation, coupled with the opinion of the banking community, because currently the deadlines are set very tightly, and it required the banks actually to restructure their management and their system in the middle of the year after the budgets have been approved. And these are huge costs. We are very often not able to take into account the bylaws and the regulations to comply with the laws that has been passed. But this is this is very often the case, that we do not know the bylaws and the detailed regulations after the laws. And the law is changed, amended very often, so that the requirements change as well. So we have it's a very difficult situation, especially for the smaller banks, for instance, who are willing to use the remote identification, but are but right now need to adapt to new requirements of the laws. And the requirements are very often unnecessarily strict. There are some other things as well. A concept for the law 1318, and we will share our vision, we will share our concept of the amendment of the current laws and of the introduction of the pre-evaluation procedure, and we will be hoping that we will stay optimistic when implementing the laws, and after mitigating those challenges, technological challenges, we'll be able to implement this much more rapidly, and we'll be able to implement very useful solutions, useful for the consumer.
Thanks. I think if you make the proposal, any discussion will have to follow after those proposals are made, and let me refer to our term. He's a practitioner in blockchain technologies, and he combines legal and technological approaches, and your input will be interesting. Yes, Alexei, thank you. Dear colleagues, indeed, for the past 5 years, I've been dealing with the blockchain technology as a lawyer. For the past year and a half, I have acquired some experience, and I'm thankful to the regulators for the fact that in 2014 they stated that we should go to the other jurisdictions to study what's going on over there, because in 2013, when I started my activity, the expectations were high, and we used to send letters to the CBR for them to explain the status of the euro currencies. The answers were funny, and we have left the zone of comfort a bit later, and now we are traveling at length in European jurisdiction to study things. I would like to draw your attention to a number of the things. To answer your question, what the law could do in the context of the development, I must say that it's hard times for the regulator, because the changes that take place, they break the model, they're very disruptive, they disrupt the environment, related to the essence of the phenomenons. And I was in Switzerland, and prior to that we had a discussion with one of the legal team who was supposed to give their resume regarding the one of the Russian blockchain projects, and it was quite funny to see how difficult it was for the Swiss lawyers to understand how it works, what is open source code, how is it applied for 100 million that attracted $100 million, and what the business model is, how you generate a profit, how you provide motivate your personnel, etc. And it is very difficult for the regulator to understand what approach they should use. Let me talk about what we can see ourselves. We are communicating with the European regulators, and each jurisdiction has their own approach. Take Malta, for example. It's a small country, and I've been there 3 weeks ago, and I met virtually all the stakeholders at the market. We had a discussion with the Prime Minister, and we have persuading them that what a great blockchain island it will be, and they are regulating things. They have a special standard for blockchain platforms. They want to perform the audit with respect to the cybersecurity, and they have cryptos exchanges and everything that is related to trading. They have a comprehensive approach, and they are engaged in PR of their jurisdictions, and there might be very interesting outcomes. We'll be following up what's happening. Another example is Luxembourg. There was first a crypto exchange over there that was set up over there. So we came to Luxembourg in hope to find an answer there, how we can work in Luxembourg. And so it was a brief answer. He said the exchange has two components. One is to receive the money, and the other is to pay money to the clients. That's what we regulate. As far as other things are concerned, like cryptocurrencies, exchanging assets, that's not our area of regulations. We don't have any deadlines. We do not regulate it. And this is the country that has the largest cryptocurrency exchange. Another example is Japan. There was reference made to Japan at length in the past at the past conferences. Last year, there were representatives of Japan in Sochi, and we had a discussion, and they said that the requirements that have been adopted in Japan are even stricter, more stringent than issuing securities and IPO. And to use the instrument, which is supposed to give an easier format of interaction, it's necessary to cover more difficult ground than the conventional projects. And Japanese jurisdiction is less lucrative, less attractive now. There are similar challenges that the US is facing. The regulator over there is vigorously introducing standards, and the regulator sets up rules for the platforms, for the exchanges, and those platforms migrating to the other jurisdictions that where have a more acceptable regulatory regime. To answer the question that Alexei has put, how law could contribute to the development of financial technologies with respect to blockchain technologies, I would like to say that it is exceptionally important to make more definite, to have the reference to cryptocurrencies, securitized tokens, etc. So there should be a number of the criminal cases reduced and the other traditional expenses. And at that, it is important not to lose track of what is the object of regulations, because the regulations by nature are conservative, and the new disruptive technologies and new paradigms that come into existence should be taken into account. And what we are doing, we are developing the centralized e-senses, like one licensed entity can work with the blockchains. Then we lose track of what we are dealing with. I have stated already that life is not easy for a regulator, and there are similar problems that many regulators face, and many undertake efforts to set up some kind of enclaves, to launch, to kick off the operations with the financial assets, and then to see what will come out of it. And I am sure that the new law on digital financial assets will show that our regulator is moving in the right direction. Okay, a question. You're traveling a lot around the world, looking for the platforms where to apply your knowledge and experience. And we had a discussion with Oliver Volker, and I asked, how is it possible to construe a model that will enable the state to fulfill its functions, like enforcing the rulings of the court. Is it possible? Thanks. I was just wanted to have my intervention when you asked Volker. We have discussed it with the regulators in Luxembourg, and I can say yes, it is possible. When we talked about their case, we have been discussing the stable coin discussion that will be linked to euro. It is a token. And we have discussed how to block the operations, how to reverse the transaction. And the easiest way is the standard multi-digital signatures when there are two signatories, if each transaction is signed, and if there are no constraints, then the signature of the operator is given automatically. And if there is a case, suit files any charges, then the signature is withdrawn, the account is blocked, and to be followed up by the other procedures. There is a technological possibility. The most important thing is to see it and implement it. Thank you for your answer. Very interesting. And I have a question for you, Anatoly, now. How are the issues that we are discussing for quite some time implemented in the law on the digital financial assets? Because it has passed a number of the hearings, and so what is the deliverable now? What is the result? Thanks for giving me the opportunity to talk. The work started end of last year, and the draft law is being reviewed for the second hearing now, and there were some amendments made last year at the period of hype when the price of the Bitcoin was $20,000, and I predicted that it will come down to 2,000, but I was wrong. It came as low as 6,000, 6.5, and initially we expected that we will attract a lot of experts to take part in the work in the State Duma, and the 200 people wanted to have their floor, to have their say, and there were some liberal positions saying that that's what will save Russia from sanctions as well, and we will be the most advanced country attracting investments from all around the world. There was an opposite approach saying that it was a fake, it will collapse, and we shouldn't just do nonsense, we should just ban it. And we realized that 200 people will not help us to finalize our draft law, and we minimized the number of the stakeholders. Central Bank of Russia, because everybody agreed that central bank should regulate the market, and the Minister of Finance, because it was the minister that initiated the draft law. And the market, Anatoly Kozlachkov, is representing the loaners, crediting community, and the Skolkovo Foundation that have accumulated the high broad man and from the investment platform, and this work covered a lot of ground. We were prepared to legalize Bitcoin, Ethereum, and we didn't use the word combination like cryptocurrency. We agreed at one of the meetings that we will refer to it as digital financial assets or digital rights, and that will be the definition in the civil code, and this particular work has been finalized for the civil code. So digital rights, the definition, we believe that that's what we will name Ethereum and Bitcoin, and we will give the key from the lock on the door to the CBR. They will test it first in the sandbox, and there are a number of projects that are related to those financial instruments, but we scrapped it. Because Oliver has mentioned that actually the the state cannot regulate what is in the trans-border spheres. And when we legalize those things, we send a message to many citizens that you can use that particular financial instrument, and the responsibility, the liability in this case is held by the state. And we decided that since we cannot regulate this particular domain, then there's no future, or the future is doubtful for it. And the fate of Bitcoin and the other currencies that has no securities under them, that no underpinning, is pathetic in my opinion. And we have decided that we should regulate in the Russian jurisdiction only. And over here, legally, realistically, we can define the rights and liability of the stakeholders, and the draft law that has been prepared and it has been sent to the chief legal service of the office of the president. It takes into account the issuance and the circulation of digital rights in the Russian jurisdiction. Those digital rights certify the requirements and the corporate rights that emerge when there is a writing in the information system based on the system of the distributed ledger. And we introduce the notion of the operator of the information system, and the operator's role is to agree on the rules of the operation of the information system, blockchain that is, and the operation of the IS is responsible for the continuous, uninterrupted operation, functioning of the information system, and for all the things working properly.
There is also a notion of an operator of exchanging the digital rates, the digital assets, and there is a new notion of an operational digital signs, operational tender, and this notion emerged thanks to the discussions with the developers. These digital objects, these probably tokens, help finish the smart contracts. But those tokens, those notes, work only according to the rules established by the Central Bank of Russia and by the law I'm currently talking about. Next, the issue with mining. I've been sharing my opinion on mining for a long time already. I considered, if we describe mining, why did we actually want to include, to describe cryptocurrencies in the law? Mining is the creation, validation of a cryptocurrencies. However, the way we define it, the law is not about cryptocurrencies, but about investments. How do we establish the framework for our investment platforms to use innovative tools to attract investments? So mining for informational systems, for blockchain, and the way we have it in the law does not make sense. It made sense to describe the mining activities as a business activities, so that we could tax them. But after a discussion with Ms. Nabiulina, we agreed that administering those business activities will be much more expensive than the tax we can extract from this. And mining is no longer that much relevant compared to a year ago. in terms of profitability. And so we decided not to touch upon mining because the only thing we need it for is to tax those business activities. Well, that's it. Briefly, thank you very much for the presentation. I would like another panelist to speak, Jana Pureskina. You've been involved in this project. Are you satisfied with this law or other unsolved issues? Thank you very much, Mr. Kuznov. I would like to start with dwelling on some initiatives we've mentioned. Identification, rapid payments. And this has been made possible thanks to Mr. Aksakov, who managed to combine the interest of the business of the state and the Committee of the Financial Markets to take every opinion into account and to enable a rapid amendment of the law. This is why our current legislation is very modern and on the same level in the developed countries. Some of the countries are even lagging behind. And this approach is applied to initiatives, to law initiatives on regulating digital assets. Digital economy has been made a state priority in many of the national projects that we have. So this is our mid-range aim. The tasks have some technology involved. The regulatory sandbox has been made for those technical experimentations, and there is a legal part, the regulative part, which is necessary for a country like Russia with the Roman-German system of law. We need to define those notions. We need to define the technologies as the objects of the civil rights system to ensure protection of investors' rights in the Russian Federation. And the key task that the Ministry of Finance insists on right from the start is the retaining the ICO model as an easy way to attract investment. Why do we work with digital technologies? To simplify, to standardize procedures, and to reduce costs. So here, we would not like to lose this unique character of new technologies to provide for opportunities for qualified investors and qualified market players to attract investments for their projects easily without being constrained too much by the legislation. So in this regard, we believe that the key documents to build the the ICO model, it is necessary to have a memorandum and to provide the company to account for, to keep the books of the investors and to regulate the principles themselves, be it a distributed registry or a non-distributed registry. And this correlates with a second law, with a second draft law on crowdfunding, where we examined the possibility for larger projects to attract funding using shared platforms, middlemen, to minimize risks for low qualified investors, to provide additional services, bookkeeping, a registry, and it is quite logical to retain this link. As to the attempt to introduce tokens into the applicable legislation of related to shareholders and financial markets, here I would agree with Alina's view. Ministry of Finance treats digital technologies as newer, more technological forms of issue of securities and derivatives, and not as self-sustaining financial instruments, which grant the same rights but with other conditions. We see a risk, an arbitrage risk, in the established system of corporate law, and we see a threat to traditional shareholders and traditional shareholder legislation. So we need to be very careful about stipulating the new regulations here. And on the whole, right from the start, when we started developing the draft law, we have seen the task of a state not to hinder the development, which we should notice and take into account. We think that the state should understand and monitor all those processes, of course, protecting the interests of the investors. Thank you very much. Unfortunately, we don't have much time left, so I am forced to give the floor to Anatoly Kozlechkov. You've also been on the working group. What are the open issues, and are you satisfied with the result? We have very little time, so I would like to dwell on a specific topic. This will be a legal one and not a technological one. This will be a motivating target for us. This technology has been created as something challenging the state governance system. This is what you read in every book. The purpose of creating the cryptocurrency system was to establish currency without involvement of the state. Next, we had the asset transactions, and the technology moved even further. And as a result, I believe this aim was achieved because the regulators all over the world did not understand how to use this technology, and the market players also weren't sure about this. So our work group in the final stage, headed by Mr. Aksakov, our target was to tell all the good apart from the bad. So everything which potentially can threaten the currently established system should be separated from the part of technology which might be useful and which will contribute to stability of the system, because the banks need stability. This is what they rely on in their activities. And when assessing the text of this draft law, you will be, of course, and critically reading this. I would like you to understand that we needed to convert this tank designed to destroy the state governance order, to convert it into a car moving along a specific route, And here I think we are among the first, or even the first, to pass a complex law governing all the cryptocurrencies. So please keep this in mind, and I'm sure that we will be criticized a lot, and we'll be discussing a lot. some of the issues are still open, some of the legal issues are still open, but we have the idea formulated in the Banks Association that we'll better create a strict regulation for this topic to make small steps separating the unnecessary from the necessary to move on. So we should start with something small and then make something bigger.
Thanks for your quote. And we have Mr. Aksakov. Once again, we are introducing regulations, how the rights emerge and how the rights are transferred. And Oliver have mentioned about the judicial protection, and our law makes all the prescriptions on how to do that, and we inbuilt it into the applicable law. But at the same time, it's liberal. Those that will be developing the exchange platforms, and I see the guys from the Crimea, they have presented the project of the investment platform, and they are just on the standby for this particular law. And when this law was discussed, participating were the authors on the crowdfunding, and these two laws will be in sync. And I think this particular law is well coordinated, and it will lay the foundation for attracting investments into the innovating companies, into startups. And I think we will receive the endorsement of the office of the president, and the State Duma will have a hearing this fall, and it will be enacted early next year. I would like to thank all the panelists, and we have run out of time, and the subject matter discussed could be talked at length over here and at the other panel sessions, and it still won't be enough time for that. But I think we will still be able to discuss the draft law. It will be the focus of the public discourse of our community. Thank you.